Thank you very much indeed, Michael. Thanks to the Brennan Center and the American Constitution Society for sponsoring this event. Ladies and gentlemen, thank you for coming. You are in for a treat. There are few books that manage to be sharp and surprising and to transform conventional thinking on one of our most contested public issues. This book is one of them. It will challenge you. It will discomfort you if you happen to be an extremist on either side of this debate, as many people are. Adam Winkler argues that both what he calls the gun grabbers, who favor total prohibitions on gun rights, and the gun nuts, who want to oppose all prohibitions, are wrong. They're wrong as a matter of policy, because their positions are rejected by the moderate majority of the American people. And they're also wrong as a matter of constitutional interpretation, because, Adam argues, for most of American history, gun rights and gun control have gone comfortably hand in hand. Dating from the age of the framers, Americans have long believed that the right to bear arms is an individual right and is important for self-defense, but that has coexisted with regulations throughout history that are far more draconian than most of the ones that are being considered today. So that is what makes this book so important and useful. And in addition to all that, it is a beautifully written narrative which tells stories from American history in such a compelling way that I know that you will enjoy reading it as much as I did. So I want to jump right in, Adam, by asking you the obvious question, which was not obvious from your introduction. How did you become interested in this uncontroversial and completely shy and enigmatic topic? What made you write about it in the first place?
It must be because I'm a shy and enigmatic type of guy, yeah. Well, no, thanks, first of all, for a lovely introduction and some wonderful compliments about the book. I will say that, like a proud parent, you never get sick of hearing good things about your book. And thanks to Michael and to ACS and the Brennan Center for organizing this event. I remember sitting in my office one day in the summer of 2008, and I looked to my wife and I said, you know, I've been writing law review articles for 20 years. I'd really like to write a book. I've been writing law review articles. My mother won't even read them because they're so dense and impenetrable. And so I said, you know, I want to write a book where I can reach a broader audience. And I said, I think I've got a great idea for, it's my own theory of constitutional interpretation, and it answers all these hard questions in constitutional law that no one's really addressed, and it could make a significant impact, and it's going to be really, really interesting. And my wife looked at me and said, who would find that interesting? And she said, you want to write a book, you should write something about an interesting topic, like, I don't know, guns. I said, oh, I could see that. But really the impetus, and the reason why she had said that, I think at that time, was that in June of 2008, the Supreme Court had ruled in the Heller case, District of Columbia against Heller, which is a lawsuit where, that is the centerpiece of the book, the Supreme Court declared for the very first time, remarkably considering all these years, but for the very first time ruled that the Second Amendment clearly and unambiguously protected the right of individuals to have guns. And after that decision was rendered, people kept calling me, journalists kept calling me. I'd been involved in the case tangentially and done some research that had been used by some of the parties in the case. And reporters were saying, well, what does this mean for the future of gun control? The Supreme Court has said that there's a right to bear arms, and a lot of gun rights people were saying, well, we're finally going to make some serious inroads in the courts and get rid of these 20,000 gun laws we have. There were gun control people who were fearful that the Supreme Court's ruling was going to be the start of a wave of lawsuits declaring gun control laws unconstitutional. And from my own study of gun rights in the past, I just thought that wasn't the case. That what I had realized was that we had always balanced gun rights with gun control since the founding era. That regardless of the controversies of the Second Amendment, the right to bear arms is one of our oldest, most established rights. In state constitutional law, for instance, almost every state protects the right of individuals to have guns for personal protection as a matter of state constitutional law. And there have been cases challenging gun control laws under those provisions going back to the early 1820s. And the overwhelming pattern of those cases is to uphold gun control laws so long as they didn't completely disarm the people. And so I wanted to take this opportunity to show that we can have a right to bear arms, that Heller is not the end of gun control, and that we can still balance gun rights with gun control while taking seriously both the fact that individuals do have a right, and that puts limits on what government can do, but also take seriously the idea that public safety, there's still a legitimate place for lawmakers to step in and enhance public safety through regulation.
Wonderful. And I love the idea of asking your mom about which topics for books you should write about. I haven't done that, and as a result, my mom is the only one who buys my books.
Right.
I'm going to try that the next time. All right, so you are surprised by the historical evidence that you found. And you have lots of evidence from the founding era and from the Reconstruction era that the right to bear arms as an individual right of self-defense was well established. Tell us about that evidence, and in that sense, was that fierce debate on the Supreme Court between the conservatives who said it is an individual right and the liberals who said it isn't really misplaced? I mean, is the individual right question over-determined, as they say?
Yeah, I think in many ways it is. I mean, so I say that the right to bear arms is one of our oldest established rights. In part, I mentioned state constitutional law. Some of those provisions go back to the founding era. Some of the original 13 colonies protected that right, and most of those constitutional provisions were added to state constitutions when states joined the Union in the 1800s. So they're very long-standing in that sense. But you also mentioned the Reconstruction era, the 14th Amendment. One of the things that I was surprised in when I did my original research on this is that regardless of the controversies of the Second Amendment, it's actually pretty clear that the framers of the 14th Amendment intended by its provisions to protect the right of people to have access to firearms. So the 14th Amendment was adopted right after the Civil War. It was one of the Reconstruction Amendments. It provides the basis for so much of American constitutional law today, from protection of your substantive rights of liberty and privacy to equal protection of the laws and protects you against race discrimination. One of the main motivating concerns of the 14th Amendment was the denial of the rights of the freedmen by southern states right after the Civil War. They passed laws like the Black Codes that basically put blacks, returned the freedmen back into a state of semi-slavery. Heavily restricted what they could do and restricted their ability to exercise their rights. And the framers of the 14th Amendment sought to protect the rights of the freedmen. And one of the rights that they were very clear about was that the freedmen had the right to have arms for self-defense. They were being often attacked by marauding groups of racist whites who were looking to disarm them. And so the 14th Amendment was, again, one of these constitutional provisions that was designed to protect this right, even over and above the Second Amendment. And so I think one of the interesting things about the dissenters and the majority in the Heller case was decided 5-4, and it was heralded as a triumph of originalism. I have my own skepticism about that I issue in the book, but one of the reasons why it was claimed to be is because even the dissenters seemed to look to originalism. A few months after the Heller case came down, Justice Scalia was giving a speech at Harvard Law School, and he said, well, look, what could be easier than originalism? Look at the Heller case. We had all these great briefs. What could be easier than figuring out how to decide this case on the basis of originalism? He seemed to have forgotten that 4 justices also used originalism and came to a completely different answer as to what the right was protected. So.
Well, on that score, you say that although you agree with Scalia's conclusion, it's bad originalism that he practices as well. So just because our audience will be familiar with the debate, the way the Supreme Court framed it, the conservatives, Justice Scalia says it is an individual right, and the liberals said no, the reference to a well-regulated militia means that it was only meant to govern military service and not self-defense. And you demolish that by noting that the amendments that a majority of states proposed after the original Constitution was drafted, because they were concerned about the lack of a Second Amendment, all referenced an individual right. You quote the Pennsylvania report that the people have a right to bear arms for the defense of themselves and their own state or the United States or the purpose of killing game, was the preamble and so forth. And a lot of examples of that. So on that point, you don't think that the liberals are correct when they try to narrow the meaning of the amendment merely to a well-regulated militia? Well,
as I said, I certainly wouldn't rely just on that report, which was actually a minority report in Pennsylvania. But I understood what the framers meant by militia was something different than what we think of as a militia. We think of the National Guard and an organized military fighting force. But there's good evidence, it's contested, but there's good evidence that what the framers were thinking of was a citizens' militia, an ordinary group of citizens who would be called out to serve in the event of war. One thing we know is that the Founding Fathers did not like the idea of standing armies. They were fearful of standing armies. Their experience with standing armies was always bad. King George had used his army to try to disarm the people of Massachusetts and Boston. In their historical memory, James II, the last Catholic king of England, had used his standing army to try to disarm a large number of Protestants, fearing revolt. And they were fearful in their new country that the President of the United States would become like a king and use the powers granted to the federal government in the Constitution to run roughshod over the liberties of the people. And so they didn't like a standing army. That would be the mechanism by which that oppression would come. So they believed that we should rely on a citizens' militia. We, the people, called out to arms, would run back to our homes, grab our guns, and be ready to fight in an instant. Hence the Minutemen of revolutionary fame. And indeed, in 1792, they passed a law, the Uniform Militia Act, that said that every free white man between 18 and 45 was a member of the militia, regardless of whether you had signed up for it or regardless of whether you really liked the idea of being part of the militia. You were part of that. So when they refer to a well-regulated militia, they're referring more broadly to a well-regulated citizenry that has arms.
And what about the well-regulated part, which the liberals put so much emphasis on? You give lots of examples of regulations in the colonial era that would have made our current ones seem tame. You say, imagine the outcry of Massachusetts today announced that every gun owner of a certain age was required to appear with his or her guns at a public gathering where government officials would inspect the weapons and register them on state rolls, as was the case in the colonial era.
It's true. The Founding Fathers believed in individual ownership of firearms, citizens owning guns. But they had very onerous gun laws of the sort that the NRA today would never accept, even though the NRA often claims to be sort of the inheritors of the Founding Fathers' vision when it comes to gun rights. They not only disarmed large segments of the population, blacks, both slave and free, were barred from possessing firearms, but even law-abiding white men were barred from having guns in some circumstances, namely loyalists. At the time of the Revolution, if you weren't willing to swear an oath of loyalty to the Revolution, you were subject to forcible disarmament. And we're not talking about traitors here. We're not talking about people who are fighting for the British. We're talking about people who are exercising their freedom of conscience and freedom of thought, who thought that taking on the strongest military in the world by these 13 divided colonies who couldn't agree on very much was probably not a very good and wise idea. That, you know, we often think when we look back at the Revolution, oh, everyone must have supported the Revolution at the time, right? Who could be opposed to the American Revolution other than George III himself? But your own experience as an American might indicate to you that we kind of disagree on big issues like this. And indeed, the Founding Fathers estimated that about 40% of the founding generation was opposed to the Revolution. So they were subject to disarmament. And you mentioned the militia laws. Very onerous laws. Gun owners had to appear at mandatory musters where they and their guns would be inspected and even registered on public rolls. And they even had their own version of the individual mandate. You know, this was the provision in President Obama's health care reform that's proved so controversial, a requirement that people go out and buy health insurance if they don't otherwise have it. And some opponents have said, well, what power could the government have to require you to buy something? Well, the Second Congress in 1792 did exactly that. In that militia law that I mentioned earlier, one of the other provisions, after saying who was a member of the militia, it required all of those people to go out and outfit themselves with a military-style firearm, whether you liked it or not. Even if you had a gun that was perfect for hunting quail, that wasn't the right kind of gun, so you had to go out and buy the right kind. So the Founding Fathers had their own version of an individual mandate. For them, the Second Amendment was not a libertarian license for anyone to have any gun anywhere they wanted.
And then, of course, the issue in the Heller case was whether D.C. could ban private gun possession in the home, and you found laws from the colonial era in Boston prohibiting keeping a loaded firearm in the home because of the danger of fire. And there was another law that said that all loaded firearms had to be kept out of buildings.
They had their own version of safe storage laws. At the time, the biggest problem was the combustibility of gunpowder, which was being manufactured by a new company that had just been formed by the name of DuPont. Still around to this day, obviously, still creating armaments and other things to kill people. But their powder, the powder was highly combustible, and there were regulations on how you could keep gunpowder. And it didn't. You don't find any objection in any of the historical materials where people said, well, if I can't keep this powder somewhere accessible to me, and I can't keep a loaded gun in Boston as the rule in Boston provided, that I don't have a right to defend myself and I'm being deprived of my Second Amendment rights. So again, their regulation was much more extensive than we often imagine.
All right, so you're criticizing both the liberals and conservatives in Heller. Justice Stevens maybe puts too much emphasis on the well-regulated militia, but Scalia, you say, and you quote one of his conservative critics as saying, after establishing that the framers did view it as an individual right, then comes up with this list of exceptions of regulations that are okay today without asking what the framers would have thought about those exceptions. It's very abstract originalism that almost sounds like living constitutionalism. Incidentally, as I ask you more about Scalia's opinion, I can't help but share this wonderful detail that Adam has. Scalia, as a kid, attended a Jesuit military academy in Manhattan and would take the subway from his house in Queens carrying a .22 carbine rifle, basically. And I wondered, why was that legal in those days, actually?
Yeah, exactly. No, he said no one ever looked twice at him riding around the subway with his rifle. Don't try that today. Don't try this at home, people. That's not going to be a good idea on your way home to grab a rifle and try carrying it on the New York City subway. But it is a reflection, I think, in part of how things have changed in urban environments. Scalia's not that old, and what he was doing was, in the lifetime of many of the people in this room. And things have really changed radically. But no, you're right. I mean, in terms of the Heller case, a lot of people, especially in the gun control community, were very, very worried about what Heller meant for the future of gun control. Fearful that, because the Supreme Court had said there's an individual right to bear arms, that would be the end of gun control as we know it, or we'd at least have serious curtailment of America's gun control laws. But I think that the Heller case is much more moderate than many people give it credit. The court went out of its way to make clear that the vast majority of gun laws on the books today are and will remain constitutionally permissible. Now, in part, I'm critical of that part of the opinion, not for saying that these laws are constitutional. I think that's right. However, for an opinion that's so grounded in originalism, to say, he has a paragraph at the end that says laws banning felons, laws banning the mentally ill from possessing firearms, laws restricting guns in sensitive places like school zones or government buildings, or schools or government buildings, or laws regulating the commercial sale of firearms would not be called into question by this ruling. But those are not laws that stem from the founding era and the Second Amendment. Those are laws that are products of urbanization and the 20th century. And when the scope of a constitutional amendment is defined by 20th century regulation, that's not originalism. That's not looking at the original meaning of the Constitution. It's living constitutionalism. It's the idea that the Constitution is changing and shifting and evolving to keep up with changes in society.
And you point out lots of difficulties about doing honest originalism when it comes to the 20th century regulations. Scalia put a lot of emphasis on the idea that you could ban machine guns because they're not in common use. But as you know, the reason they're not in common use was because of New Deal era gun control regulations that banned machine guns. So you can't, that bootstraps the question of whether those regulations are permissible. All right, so if you were an honest originalist, and I'm not asking whether you would be an originalist if you were a justice, but imagine you were Justice Scalia. What should Scalia have done to evaluate the constitutionality of the Chicago ban, and what does the history tell us about what future regulations would be called into question?
Right. Well, I should say I'm not an honest originalist, not even a faint-hearted originalist like Scalia likes to claim him to be.
You are not and never have been an originalist.
Yeah, exactly, right. And I don't think that originalism is the right way to think about constitutional interpretation. I think that original meaning is something that is a factor that goes into the analysis. But one thing I do think, and I think one of the things I tried to get through in the book, is that in defining the scope of these constitutional rights, one of the things that is another valid factor that we should look to is the history and tradition of efforts to regulate in this field. It's not just about the original meaning, it's about the Constitution that we've created in the years since and how we've approached these legal issues. And so an honest originalist, if Scalia really wanted to be an originalist, would have gone back and said, okay, what exactly were the founding era laws? What analogies can we draw to those laws to today? It doesn't mean you have to have the exact same laws, but you can draw the law as a game of analogies, essentially. And he could have done a game of analogies and tried to figure out what kind of laws we have today that are analogous to the laws they had on the books. We talked about safe storage of firearms. That's a good example. So that might mean that certain kinds of safe storage laws, even if they burden one's ability to use a firearm quickly in self-defense, might be constitutionally permissible. So there are ways in which you could have drawn those analogies, but he didn't do that, and I think there's a really good reason why he didn't do it. America's problems with regards to guns and urbanization are far more profound and far more different than they were in the founding era, and restricting ourselves to what the founders did would not lead to effective gun policy, and it wouldn't lead to very edifying and satisfying constitutional law either.
Do you think the bottom line conclusion of Heller and of the subsequent case McDonald, namely that total bans on gun possession in the home are unconstitutional, is consistent with honest originalism, that the framers would not have wanted to completely ban the use of guns?
No, that's right. And like I said, I mean, they did ban possession of firearms for segments of the population. Blacks, slaves, and loyalists, as I mentioned, at least were subject to disarmament. So there's some evidence that they did that, but I certainly wouldn't want to use the fact that they disarmed African Americans as part of a racist effort to maintain a sort of a slaveocracy and racial apartheid in America is the kind of analogy we should be drawing to make an argument in favor of gun bans today. And arguably, of course, gun bans are far different in that a law like Washington, D.C. law, which was a complete ban on handguns and a restriction on the use of long guns for self-defense. That was the law at issue in the Heller case. That law obviously reached far beyond just segments of the population being disarmed, and it was an effort to try to disarm virtually the entire civilian population. The law in D.C. was interesting. It banned handguns and said you could have a long gun, a shotgun or a rifle in your home, but you had to keep it locked or disassembled. You could unlock it and assemble it under the statute for specified recreational purposes. But a D.C. court had said, well, if someone's breaking through your window, determined to commit a crime, and you're there and you have your firearm, could you use self-defense? And the court said, no, that's not a recreational use of the firearm. And I guess that's not recreation, as we understand it. And so you weren't allowed to use your firearm. So you could have a gun in your home that you were allowed to have, and someone could be coming in to attack you and threaten your life. And by the law, you're allowed to use self-defense and even use of force that results in death if someone's threatening you in an imminent way. But the only thing you could do with a gun maybe is beat someone over the head with it viciously rather than actually shoot it. So it was the most extreme gun law in the nation, and did, I think, validly raise concerns. What right of self-defense is there if you cannot use a firearm against someone who's coming into your window and who might be armed themselves?
And in addition to being arguably unconstitutional, you think that these total bans are romantic and symbolic laws that are ineffective and are bad policy as well?
Well, absolutely. I mean, Washington, D.C., when they passed their law in 1976, it was a perfect example of sort of the idealism, or aggressive idealism of some who want to get rid of all the guns. I can understand why someone might think that a world without guns is a better place than a world with guns. I get that attitude. There's 280 million guns in America today, almost one per person, certainly more than one per adult. They're not going anywhere, and they're never going to go anywhere. We've tried to outlaw alcohol with prohibition. It was a terrible failure. We've tried to outlaw various narcotics and other drugs with the war on drugs. You can make your own judgments. My view is that's been a terrible failure, resulted in the loss of civil liberties and a huge war on drugs that's been incredibly cost inefficient and ineffective. So getting rid of the guns I don't think is really an option, but in D.C. they really thought that by passing this law in 1976 that they would start a nationwide trend to get rid of all the guns. In fact, Marion Barry, who would go on with some notoriety in his career in Washington, D.C. at the time, was a city councilman, and he said something interesting. He said when they were debating the law, he said, this law will not take one gun out of the hands of one criminal. And he was a supporter of the law. He was voting for it. But the idea was, idealistically, we could start a nationwide trend because this is Washington, all the other cities will follow us, and soon we'll get rid of all the guns in America. Not only did it never catch on, right? Only Chicago was the only other major city to completely ban civilian access to handguns. But when I moved to Washington, D.C. to go to college there in 1987, it was the murder capital of the United States. Obviously, getting rid of the guns didn't get rid of the guns. It didn't start the trend that it started, and really left a situation where even law-abiding people who were threatened and had their lives threatened couldn't defend themselves.
I'm going to let you bash conservatives in a moment because I think our audience may be getting quietly restive. But I want to ask, you're also not a fan of the assault weapons ban either, during the Clinton years, which you think was basically symbolic politics that singled out a gun that wasn't much more dangerous than other guns.
I think it was when I started writing this book and I started doing research, I thought, oh, of course banning assault weapons is a great idea. What need do we have for these kinds of machine guns out on our streets? It was when I did the research and I realized, oh wait, we're not regulating machine guns. Machine guns have already been extensively restricted in their access ever since 1934 in the National Firearms Act of 1934. What these assault weapons were commonly thought to be machine guns, but they're really just rifles. And actually, as rifles, what they shoot are ammunition that is intermediate size and not nearly as lethal as what you'd find in a deer hunting rifle, for instance, that weren't banned. So basically, you had a law that regulated these firearms really on, imagine a spectrum of all the lethal rifles you could have. Well, it said, well, we're going to allow almost all those rifles to exist, and we'll take out a small little segment of those rifles. Not even the most powerful ones, but the ones that look the meanest. What makes an assault rifle an assault rifle is that these were weapons originally designed for use by military servicemen in the war context. So it was lightweight, made from lighter polymers and whatnot, and often had features on it that were distinctly military, like a bayonet plug or a second pistol grip. And the law, because it was only regulating this small little segment of firearms, focused on, and it didn't focus on the lethality of the weapon, which would have led to things like deer hunting rifles being outlawed. Focused on these superficial characteristics for the most part. What are the bayonet plug and the pistol grip? And as a result, manufacturers simply skirted this law very easily by producing the exact same weapon without the bayonet plug, without the pistol grip. And so it did not stop the sale of assault weapons at all. And in fact, over the last 15, 20 years, the most popular gun in America has been an assault weapon, the AR-15. So it was a kind of law that was kind of a feel-good law, but didn't really do much to restrict access to dangerous weapons.
And in addition to that, you suggest it may have lost the House for the Democrats in '94 because it became an election issue for the Republicans.
Well, Michael and I were talking about this just beforehand. Michael was working in the Clinton White House at the time, and he's not a believer in the theory that the gun control laws led to Democrats losing the House for the first time in 50 years in 1994. When the last time we saw Newt Gingrich rise to the top of the polls was in 1994. But at least reasonably astute commentators have disagreed with Michael. Bill Clinton himself said that the reason why he lost was because of the gun control laws that he pushed, including the assault weapons ban. I don't know exactly whether that's completely accurate or not, but it's certainly one of the factors that went into the defeat of Democrats ever since then. And certainly Democrats have taken the lesson since then, is that they need to have better support for gun rights than they did in the House.
Yes, and as you say, Nancy Pelosi, in your view, wisely refused to bring back the assault weapons ban because she thought it would kill the Democrats.
Right, and for very little gain in terms of reduction of criminal violence. Like I say, these guns are already out there, and the manufacturers were still making them and just skirting the law very easily.
Right, I see furrowed brows in the audience, so now I have to stress that you also are just as tough, if not tougher, on the what you call the gun nuts on the right who oppose any regulation. You note that the NRA, for most of its history, was a fairly moderate organization that didn't even mention the Second Amendment. It was founded by a New York Times reporter who wanted to promote responsible gun use. And it seems the policy that you direct most of your ire toward is the NRA's opposition to meaningful background checks, the gun show exception, which led to the Virginia Tech shooting and to a lot of other tragedies. It's so easy to get an unregistered gun. You think that a lot of the problem would be solved with tougher registration.
Yeah, no, we've talked a lot about my criticism of various gun control laws. I'm extremely critical in the book about the gun rights movement and some of the people in the gun rights movement for promoting a very extreme view of the Second Amendment. And one that's very recent. When you talk about the NRA, founded after the Civil War, like I say, by a former reporter for the New York Times, and it was formed, it didn't have anything to do with gun rights or the Second Amendment. It had to do with the fact that the two people who formed it were Union soldiers, and they thought that the reason why the Civil War had gone on for so long is because the Southern soldiers were really much better familiar and much more experienced with guns. And as a result, they were better shots than the Union soldiers, who often hailed from cities and had very little experience with guns. And so they wanted to promote marksmanship training so that we'd have a better fighting force. But in the 1920s and 1930s, the NRA was hardly the no-compromises opponent of gun control we know today. In fact, they were at the forefront of the gun control movement, pushing, drafting, and promoting in state after state restrictive gun laws on things like concealed carry of firearms, that swept the nation at the time, promoted by the NRA. And those same laws that the NRA today seeks to try to overturn in court. When I mentioned the National Firearms Act of 1934, which imposed these heavy restrictions on machine guns and other kinds of gangster weapons, the head of the NRA was asked to testify about this proposed new law. And his answer, he was asked, does the Second Amendment impose any limitations on what Congress can do with this National Firearms Act? And it was his answer from the perspective of today is quite remarkable. He said, I've not given it any study from that point of view. So the Second Amendment was not part of the lifeblood of the Second Amendment. And in fact, if you go through the American Rifleman, which is the NRA's signature publication, for decades, 20s, 30s, 40s, and 50s, as I've done at the library, you can't find the Second Amendment mentioned anywhere in the magazine. All that changes in the late 1960s and early 1970s. And now if you pick up the American Rifleman, I can guarantee you'll find the Second Amendment mentioned on almost every other page.
And you tell the story of why it began to be mentioned more for political reasons, but it really got up and running in the 1980s. Was that just part of the general post-Roe v. Wade legalization of politics? Why did it become such an issue for the right?
Sure. Well, certainly it was became part of the coalition of the New Right that was focused on making its claims in constitutional terms. I mean, one of the things that the New Right did, it mimicked the left and the Warren Court and the work of Justice Brennan quite well by saying, hey, you know what, we need to start thinking about framing our policy preferences in constitutional terms, whether it's the pro-death penalty, favoring tearing down the wall between church and state, expansive private property rights, or gun rights. It was about, we need a vigorous judiciary to protect the rights that we care about, too, not just the ones that are going to be pursued by the left. The NRA itself changes literally overnight. The NRA, the leadership of the NRA in the 1970s decides that they announce that they're going to retreat from political activity. They're going to move the headquarters to Colorado Springs and focus on outdoors activities and hunting. And this upsets a dissident group of hardliners in the gun rights movement, people who were coming to believe that guns were not about shooting ducks, but about protecting yourself from a criminal attack in a big urban environment. And these dissident hardliners led a coup, literally at the overnight, at the annual meeting of the membership in 1977, through a strategic plan that they had mapped out in advance. They basically mounted a hostile takeover of the organization, and by the next morning, they had manipulated the votes and manipulated the rules of the NRA's voting membership to install a completely new board of directors and new leadership of the NRA that was committed to a hardline view of the Second Amendment and determined to refocus on political activity and opposing gun control.
So did liberals fall into a trap in allowing themselves to be equally polarized and resisting the newly extreme claims of the right? For example, you quote the lawyer, Mr. Gura, who argued against the DC ban, as being surprised not that he won, but that he didn't get a single liberal justice on his side. Right. And it was also surprising, given the consensus with which the idea that the Second Amendment applies against the states has been accepted in the legal academy, that not a single liberal justice voted for that either. Were the liberal justices just too polarized on this issue?
Well, it's hard to know exactly. I mean, I think that the Democratic Party has gotten it wrong on guns from the get-go. Originally, the attitude was we should get rid of all the guns, represented by DC's law. I think that didn't last very long, in part because it didn't really go anywhere. It wasn't a successful political strategy. And so then the Democratic Party started putting in its platform things like, well, we support the rights of hunters. But again, I think it really misunderstands the nature of the gun rights movement today, to think that people who are gun enthusiasts are all people who love hunting or recreational shooting because when they were 12, they went on a hunting trip with their dad and they got their first rifle, and now this represents their family and their culture and their community in a way that's very profound and personal. While I think there are those for whom that is accurate, I think the real heart and soul of the gun rights movement today are people who think you need a gun for personal protection against a criminal attack. And in the late 1960s and 70s, we had skyrocketing crime and gun violence. A place like New York was a very, very dangerous place to live. And people wanted guns to protect themselves. Law-abiding people wanted guns to protect themselves from those attacks. It's hard for me to say that the justices were too partisan. I mean, it's always hard with, I think the justices are generally pretty good at trying to focus on the law, but the law is always ambiguous, and where the law, in this case, there wasn't a lot of precedent for the court to look to, it was very easy for those policy preferences to manifest themselves.
Now, to say something in defense of the liberal justices, two of the most respected conservative lower court judges, Judge Posner and Judge Wilkinson, were withering in their criticism of Scalia's majority opinion. They called it bad originalism. They said, Posner said that the history was actually on the other side. Wilkinson said this was Roe v. Wade redux, and the conservatives were doing exactly what they accused liberals of doing, using the judicial process to short-circuit political debates. Anything in that traditional defense of judicial restraint that appeals to you?
Well, I think that's right. I think it reflects actually a real divergence in the conservative legal movement. There's one side of the conservative legal movement that really emphasizes judicial restraint. We need to keep the courts out of the political process, allow the political process to operate effectively without the interference of the courts, overturning the will of the people. But then there's this other element of the conservative legal movement that's been prominent over the last 30 years, which is the side that I mentioned earlier, that we need the courts to step in and vigorously protect the rights that we hold sacred. And I think that that side of the conservative legal movement has been much more powerful in the courts, was much more powerful in the Reagan administration, I think, and in the second Bush administration as well, in terms of who they picked to be on the court. These are not modest people who are committed to judicial restraint. Sorry, Chief Justice Roberts, they're not really umpires calling balls and strikes the way they like to say. And that activist version of conservative legal movement has really been much more profound and much more powerful, I think, these days.
Back to the polls, you quote a lot of fascinating ones, but really the country is quite moderate in these issues. You say 72% of gun owners, according to a recent poll, support background checks in a waiting period. 66% support extending background checks to private sales. That reform you think is so crucial. 79% support mandated gun safety courses. And I don't have the numbers right in hand, but something like 11% or something support total no restrictions at all. So the hard right has placed itself in a position that's out of the line with the majority of the country as well.
That's right, and one of the reasons why I think it's important for the left to embrace the Heller decision, or at least not try to overturn it and make it the Roe versus Wade of the left, is that I think that Heller provides an opportunity to reach out to those people. There's a lot of gun owners who will not support gun control because they really are fearful that the government's coming to take their guns. And that I think that one of the things that Heller does, and can be so profound for the gun debate in America, is by saying government can never come and take all your guns, that you have a constitutional right to have those guns. And as a result, I think in the long run, my optimistic view is that in the long run, that if that case becomes more part of our constitutional fabric and our constitutional ideas and our constitutional identity, then a lot of those people who won't support gun control today, even though they support it when when pollsters ask them, I think that they'll be more likely to support gun control laws in the future. They feel that it's not going to lead to their rights being completely denied. And I think the essential condition for that to happen is that the left can't try to overturn Heller in an aggressive way. I think then we'll just end up with what we've had with Roe versus Wade, which is just 30 or 40 years of contestation that doesn't really move the ball forward in any positive way for public policy.
The Tea Party right and the Occupy Wall Street left are finding common cause in their opposition to the banks and to financial oligarchy. Are there any? Is there any gun support on the economic populist left?
There is, but not that much. I think that maybe it's a growing group of people on the left who are libertarian. I'll tell you, one of the things that I find in teaching my class, one of the things that I've been surprised with over the last 10 years, I don't know if Jeffrey you found this similar in your class, is that a lot of my students are not partisan. They're not Democrats, they're not Republicans. A lot of them are sort of libertarian. And I don't mean that in the Republican sense of libertarian, but really they don't have a lot of faith in government. They really think that the best thing is to be left alone, to be able to do what they want to do. And I think that that's a sort of a growing movement among our youth, is that sort of libertarian, just leave me alone, let me do what I want to do. And to the extent that applies to drug legalization, you're seeing that on the streets today with states moving towards medical marijuana laws and other liberalization and permissive laws towards drug use. And I think a lot of those people believe the same thing about guns, that there's a valid place for government to regulate guns. But at the end of the day, if you're a law-abiding person and you haven't done anything wrong, stopping you from having a gun in your home is something that at least a lot of my students seem to think is a good idea, that allow people to have that right. And I think it's part of that libertarian turn.
Your book has obviously made the heads explode of extremists on both sides, of the gun grabbers and the gun nuts, but which side has it generally upset more, the left or the right?
Well, it's hard to say. I've been viciously attacked by both.
Congratulations.
I'm happy. I figure I must be doing something right. But actually, I mean, one of the surprising things is as I've gone around the country, and I've been doing a little book tour to support the book, what I found is so many people come up to me and say, you know, it's wonderful to be able to have a talk about such a controversial issue where you're willing to take both sides seriously, criticize both sides where you think they're wrong, and not be dogmatic in one particular view on one side or the other, and let that be your guiding force. And I find so many people out there, gun owners who come up to me. I had an event in Atlanta, and at the end of the event, I'm getting into my car outside, and one of the guys who I talked to afterwards said, hey, I want to show you something. Someone showed me his gun, right, that he was carrying. In Atlanta, everyone's packing, apparently. And he was carrying his gun, but he said, you know, I carry this gun everywhere I go. But you're totally right. We need better background checks. We need to do more to keep felons and the mentally ill from getting their hands on firearms. You know, this is a person who wants to see gun laws made more permissive so people can carry guns almost everywhere. But at the same time, he thinks that we need more gun control. We need better gun control. And that's the way I like to think of it. It's not that we need more gun control. We don't need less gun control. We need better gun control. We need to do more to keep the worst people from getting their hands on the most dangerous weapons, and do a little bit less to stop the law-abiding person, who really isn't the threat. It's really not the problem with guns in America, from being able to exercise that right.
Excellent. We're in the spirit of engaged and respectful debate. We have some time for questions. So, ladies and gentlemen, please raise your hands. Yes, sir.
Thank you. I have a public policy question, but before I ask it, I just wanted to say that I was under the impression that with respect to Virginia Tech, that a background check wouldn't have prevented it because the mental health commitments actually weren't in the system that they used. But my question is just simply this. Do you have an explanation from a public policy perspective why President Obama hasn't introduced any gun control legislation this term, and whether the hearings that are going on now regarding the Fast and Furious will in any way impact his decision whether, if he gets a second term, to introduce any legislation in the second term?
Right. You know, when President Obama was running for office in 2008, it was right after the Heller decision had been decided, had come down, and the NRA acted like the Heller decision had never been decided, and they talked about Obama's 10-point plan to eliminate the Second Amendment, as if the Supreme Court hadn't just said you can't eliminate the Second Amendment. And I think that one of the surprising things for many in the gun control community is how lukewarm President Obama's support of gun control has been. After 2 years in office, the only gun laws that he had signed were laws that actually were more permissive, allowing guns in national parks and allowing guns on Amtrak, two laws that had been put in place by the Bush administration that was arguably much more pro-gun. And indeed, the Brady Center gave President Obama an F rating. The leading gun control organization in America gave him an F rating. I don't see President Obama pushing for any gun control right now, in part because there's no political will. He doesn't have the votes, and I think Obama is relatively pragmatic, that he's not going to push for something if he doesn't have the votes. I think that angers a lot of people on the left, that he won't push for things if he doesn't have the votes, but I think that's part of his pragmatism. And I think the Fast and Furious scandal is only going to provide more disincentive for him to push for gun control laws. You're right, you mentioned Virginia Tech. The unfortunate news is that there was another shooting today at Virginia Tech. A police officer and I believe another student were shot and killed. We don't know all the facts of what exactly happened, but it was another Virginia Tech incident. The Virginia Tech massacre was the worst school shooting at the time, maybe even still, I can't remember, but 30-something people were shot and killed at Virginia Tech. And One of the issues there is you say the background check didn't catch the shooter, Mr. Cho, and in part you're right, it didn't catch him because the background check system we have today is fundamentally flawed. We have a background check system that applies only to 60% of lawful gun sales. So if you buy a gun from a federally licensed dealer, you have to go through a background check. But if Jeffrey Rosen has a nice collection of guns on his own, and he meets me at a gun range, and I say, boy, I really love that gun you're shooting there. He says, well, you know, I'm thinking about getting a new one. I'll sell this to you if you want. Okay, I can give him the money, and he can give me the gun right then. He doesn't have to do a background check, and that's the idea behind, you hear about the gun show loophole. There's really no loophole in federal law for gun shows. Gun shows operate under the exact same rules as every place else, so it's not really an accurate description to call it a gun show loophole. What it is a private sale loophole. If you're a private seller, not a federally licensed dealer, you don't have to do this background check. So 40% of current gun sales today, lawful gun sales, occur without a background check. That's a flaw in the system that's really fundamental that needs to be changed. And then we need to have a background check system that has the records in it so that we know whether someone's a felon or someone's mentally ill. If someone has we need that data into the system so that we can deny the person who tries to buy a gun the ability to do so easily. And so our current background check system is very, very flawed and is clearly in need of major reform, I think.
Based on what you know, is the United States the only country with a history of so much debate about individual gun rights, and has other countries had this kind of background or had similar debates that we're having here?
Well, certainly our debates are more profound than any other country, and more recent too, by the way. One of the things that I found in writing this book is that when I say that there's a long history of gun rights and gun control living side by side, it's not just descriptively they live side by side, but it's also a story of there wasn't the same kind of debate that there is now. The debate has really shifted. In the Wild West, I have a chapter in the Wild West had the most restrictive gun laws in the nation. You know, we all know this image of the Wild West where gunslinger comes into town, he's got a 6-shooter on each hip, a rifle in his hand, ammunition strapped across him, maybe even a little Derringer hidden in his pant leg. You know, by the time he gets to the saloon, it's amazing he can even sit down. He's so loaded down with iron, right? But that image couldn't be more wrong, that in the Wild West, we had very restrictive laws, and when you were a newcomer to a Wild West frontier town, you had to check your guns with the sheriff, the way you check your heavy overcoat at a restaurant in January in New York City. And you get a little token that you could use to get your firearm back. In fact, I have a picture in Gunfight of Dodge City taken in 1879. Dodge City formed its municipal government in 1873. You know what the very first law they passed was? A gun control law, banning concealed carry of firearms, later extended to banning open carry of firearms. And I have a picture of Dodge City, Kansas. You don't see it here very well, from 1879. And the street looks exactly like what you'd expect a Wild West street to look like. It's got broad, dusty roads, brick and clapboard building. There's even a little horse tie in front of the saloon, of course, for you to tie up your horse. What you're not expecting to find is the billboard in the middle of the street that says the carrying of firearms strictly prohibited. This is the first thing you saw when you came into Dodge City. You were not allowed to carry your guns in Dodge City. And it didn't spark the kind of debate that we have today over these very same laws. Concealed carry laws are much more controversial today than they were back in the 1870s. So in our own debate, it's pretty recent. With regards to all the other nations, you know, there's you look internationally, you find different results. You know, in not so much with regards to the debate but about the nature of guns and gun violence. We often think that more guns, more crime. It's not that clear that that's the association. Switzerland doesn't have a standing army, and they have the old school citizens militia that the founding fathers believed Americans should have. So when you're 18 years old, the Swiss government issues you an assault rifle and a box of ammunition for you to keep in your home. And those guns are never used in criminal activity. They could be. Someone wanted to go kill 20 people and kill themselves, they could use that gun, but they don't. Americans' propensity for violence is very unique to America, and it is not about the guns per se.
I agree with everything you're saying, except for one thing. I don't detect the reason on the right at all. I think anybody who exerts any influence is going to get punished with overkill politically. But I can't move on the way we all want to move on without disposing of that clause with a comma. And the problem that people were exulting over before the decision, and now nobody really quite talks about. It's a very ambiguous phrase. What do you think they meant by that plus the comma?
Yeah, if
Is
you
it
read
just
the,
bad grammar or what?
right, no, the text of the Second Amendment is really maddeningly ambiguous, right? I mean, it's a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. It's almost as if Madison, the author of the Second Amendment, had just discovered the comma and wanted to use it as many times as possible, because none of it makes any sense with the commas, right? None of the common conventions about how you use commas make sense in the context of that.
Doesn't make much more sense without the comma.
No, it probably doesn't make more sense. But I think the idea is that the framers believed that there was the right of the people to keep and bear arms. That was not collective right any more than the right of the people to petition government for redress of their grievances. In the First Amendment was a right of the collectivity. It was an individual right. The Fourth Amendment, the right of the people to be secure in their homes from unreasonable searches and seizures. An individual right, not a group right, a right that individuals have. And that's how the word people is generally thought of being used in the Bill of Rights. So I think that that's right to think of it as an individual right based on that terminology. But they did believe that the reason why you needed it.
You have to disengage the phrase before to do that.
Well, no. And the reason why they thought that individuals had to have the right to bear arms was because a well-regulated militia was necessary to the security of a free state. Remember, I said they don't support standing armies. They think that we need a militia, citizens' militia. And then we need people to have guns so that they can protect their liberties and they can protect the nation if it's attacked. Remember, they thought their experience, the Founding Fathers, was with King George trying to steal their guns, trying to take their guns away from them in places like Boston and Massachusetts. And they were fearful. And what really sparks the revolution, obviously there's a lot of big philosophical and ideological and economic and structural issues that lead to the American Revolution. But the spark that ignites the revolution at the end of the day is when George III decides he's going to take the guns and start seizing guns out of arsenals. That really is, at that point is when the revolutionaries say, you know what, now we have to fight. Because if he takes our guns, we will be subjected to oppression and tyranny. And that we will not have any rights, and that we will become slaves under George III. It's a very different understanding that we have today. We don't generally think that, or many people don't generally think that an armed citizenry is helpful for protection of liberty and the limitations on government power. But the framers did. I think they fundamentally did understand it in that way. And so I think that's what makes the best sense of all those commas, I guess.
That makes Scalia right then.
Well, I think he was right in that side of reading the Second Amendment. Yeah, I do.
So it says, it really means because the well-regulated militia is important.
Yeah, or one of the reasons why we need this right. Right. There's a lot of ways it's been picked apart. There's a considerable literature on trying to figure out the textual ambiguities of the Second Amendment. At the end of the day, what?
Are you a student of that? Did you go to?
Well, I looked at it a lot, actually, and it's very not very edifying at the end of the day. I mean, I think at the end of the day, in terms of my own view of the Constitution, is I think that we should understand the Constitution in its evolution, not just in its original meaning. And I think one of the things that it's difficult sometimes for me as someone who's somewhat left-leaning is to recognize that if you're really committed to an evolutionary Constitution and to the whole Constitution, is that you have to recognize that it's not only the left that gets to shape what that Constitution means, and that we, the people in America, have spoken over and over and over again about what their feelings are on the right to bear arms. And that's reflected in state constitutional law, in polling, congressional legislation, and I think ultimately in the Heller case itself. That's an evolutionary vision of the Constitution.
One more question. Yes, sir.
What they were trying to do in proposing, Madison proposing the amendment, was to make sure that the Constitution they had written would be adopted by the states, which was not a sure thing. And they thought that one of the ways to ensure that was to say the states will continue to have their militias, but they could only do that if the Constitution recognized a right in common law, an individual right, which was to have guns. Do you agree with Scalia's conclusion, which kind of is striking. I mean, I agree that it shouldn't be overturned. It is an individual right, but he says it elevated the right of self-defense to above that of all others, all the rights. I don't see that anywhere.
And there was not a lot, you can go through the founding era material, and to the extent you find discussions of self-defense, it's a different kind of self-defense, I think, than what we often think of, that it's much more tied to self-defense writ large, right? Defense of liberties, defense of a democratic populace against a tyrannical government. I think that is part of the story of the Second Amendment. I think that sort of vision of the Second Amendment has no chance of being adopted by the Supreme Court, and indeed courts since the founding era and state constitutional law, for instance, have consistently read the right to be about personal self-defense, ever since, really since the 1820s. And so, again, believing in how tradition and evolution shapes constitutional meaning, that was a vision of the Second Amendment and the right to bear arms that changed quite radically. You know, just one final comment, because I know we're ending it up. One of the most, we didn't get a chance to talk about one thing that I found most interesting in doing my research, and that I think you might find most interesting if you get a chance to look at the book, which is the close intersection, unfortunate close intersection of race and gun control. That part of the story, I mentioned the Founding Fathers, but part of the story of gun control, up until I think really into the 1960s even, that race was really an essential component of many gun control laws. The KKK began in some ways as a gun control organization determined to take the guns away from the freedmen who first got guns, got their hands on guns in the Civil War, and up until the days of the Black Panthers, when the Black Panthers sparked, and riots in places like Detroit and Newark sparked a new wave of gun control laws. And it's really, especially for people on the left, it's one of the disturbing things to discover. It's not to say that gun control is racist, but that they're, in understanding the history of gun control, understanding the way that race and racism were promoted and manifested by the idea of getting rid of guns when they were in the hands of blacks, is really a fascinating part of the story, and something that if you do get a chance to look at the book, I think you'll find really interesting. Thank you.
Well, thank you so much for this conversation. I think you got a taste of how interesting the book really is. We should mention that we do have copies for sale here, and I'm sure that Adam Winkler would be happy to sign them. And we want to thank, and he's got his own pen, which is concealed carry. We want to thank Adam Winkler and Jeffrey Rosen for this conversation. And thank all of you.